Okay, that's prayed for by Mr. B. Laramega, Learned Counsel, for the
respondent number 1, my lord.
respondent number 1, and not objected to by the other side. List again after 2 weeks.
Much obliged.
My lord, part 2, item number 13, as agreed by all the parties, if the matter may be listed on the first week of August, my lord.
Okay, as agreed to by the parties, list the matter for hearing in the first week of August.
Obliged.
May I seek your Lordship indulgence in mentioning one unlisted item, Lordship. It is a review petition which we filed yesterday. If the matter can be kindly taken up after, as the last item, just for
Review.
issuance of notice, yes, Lordship.
Review which order?
Yeah.
Order passed by this court.
Yes, Lordship.
Have you filed it?
Yes, Lordship. Yesterday.
When? Yesterday. Okay. Get listed.
Duly obliged.
May it please your Lordship.
Yes.
Lordship, I beg to mention item number 8, your Lordship, with the consent of the other side. It would be preferable to list on 21st of August, your Lordship. We have
8 of the hearing list.
Yes, Lordship, the daily list.
Daily
item number
list.
8. Item number 8, your Lordship.
No, which list? There are 2 lists.
Daily list, Lordship, daily list.
Daily.
Daily list, yes.
What is your name?
B. Sohoria.
You're for the applicant?
Yes, Lordship. Yes, Lordship. On behalf of G.R. Datta.
When do you want it?
On 21st of August, your Lordship, we have taken
Yes.
consent of.
Other side, on the request made on behalf of Mr. G.R. Datta and on opposed to by the other side, list the matter on 21st of August.
21st of August, Lordship.
Okay.
Much obliged.
All right.
Any other mentioning item?
Call.
For order, item number 7.
May it please your Lordship. Lordship, as per the office note dated 22/7/2026, service upon respondent number 2 is still awaited.
My lord, I'm for the respondent number 1, the claimant, and I had filed my objection to the IA on 2/7.
Who is respondent number 2?
Respondent number 2 is the owner of the vehicle, Lordship.
Okay. When was the notice sent?
Notice was respondent number 2.
24/7.
Yes, Lordship.
Please write. Parties are represented by the respective counsels, except for respondent number 2. Respondent number 1 has already filed the objection to the IA. So, as for respondent number 1, as for respondent number 2, neither AD card has nor unserved notice has come back. So, under this circumstance, registry shall track the postal consignment and put up a note by the next date. List the matter again after a week.
Deeply obliged.
Item 9.
No one? None appears for the applicant when the matter is called. Although you are there?
Yes, Your Lordship, on behalf of Mrs. Mary.
Huh?
On
Linda?
behalf of Mrs. Mary.
Although Ms. Lalnundui, learned government advocate, appears on behalf of Ms. Mary L. Kiampe, learned additional PP. What is your submission?
Your Lordship, I have been informed that the TCR has been received and if the matter may be listed on Monday.
Not TCR, this is a case diary.
Yes, that, yes.
Bail application.
Yes.
In view of above, list the matter again on Monday. Give the date.
Much obliged, Your Lord.
Item number 10.
No, you write one more line. However, Ms. Louis Land, government advocate, or what did I say? Don't write, read that. No. Although so-and-so appears on behalf of Ms. Mary Alquiante and submits that the case diary has been received. Stop. In view of above, list on Monday, huh? Yes. What is this?
My lord, I have received a copy of the written objection in special leave to file appeal against acquittal yesterday.
Yes, Your Lordship. In this matter, the same.
Why do you put special?
It is a special leave as per the BNSS.
Is it so?
Yes.
Let us see which provision.
419. Your Lordship may kindly come to 419.
This is the appeal against acquittal.
419.
Yes. Your Lordship may kindly come to 419, subclause 4.
Okay. The special thing has been introduced.
Yes.
Otherwise, it was leave to appeal.
Yes, my lord.
Okay. Now, you are the
I'm the counsel for the...
applicant.
Yes, my lord.
My Lord, I'm for the respondent, and I was acquitted by the trial court.
Okay.
So we will be filing our objections during the course of the day. I've already served a copy to my learned friend.
You have only appeared recently.
No, my Lord. What happened was that I had some miscommunication with my client. She was in Shillong and I could not reach her. So that's why I had some issues with obtaining the the signature. And her the permanent residence is at the Kamla Nagar.
Okay. The appeal has to be taken up by a single bench or a division bench?
My humble opinion, it will be a single bench, my Lord.
Single bench.
Yes.
What was the charge? PC Act.
PC Act,
Oh, okay.
131AB and 2.
So
Okay.
basically, in this case, Your Lordship, one of the preliminary issues that we're raising is that they have filed the law Ayukta itself has filed the appeal. So whether that is permissible or not,
Who has filed the appeal?
the Lok Ayukta itself, the statutory body itself has filed the appeal.
The state has given us permission to file appeal.
Okay. Mr. Silal Fagzo, learned counsel, appears for the applicant and submits that the instant application is an application seeking special leave to file an appeal against the order of acquittal of Mr. Lal Fakoma, learned counsel, for the
So
sole respondent, submits that he will be filing objection to the interlocutory application during the course of the day.
my Lord.
Review of above, list again. When? Next week?
If possible, my Lord, can it be sometime in September? Because I have some personal difficulty in the sense that
September. Why
we're
is such
expecting
a
our-
distant date?
we're expecting our next baby, Your Lordship, anytime.
So you finish up this matter. Then concentrate on that.
Yeah, otherwise you'll be busy. after
Because August is
September.
slightly tricky for me, so that's why.
No, we are still in July.
I understand, my Lord. Next week I have quite a number of fixed items. That's why.
What do
I
you
don't
say?
see how it.
I think that's a genuine case, my lord. He's going to have a baby, my lord.
may or may not.
Okay, so when do we have? August?
Or otherwise, what we can do is last week also fine.
As Paidfall is the matter in the last week of August 2026. IA be filed in the meantime. I'm sorry, the objection be filed in the meantime.
Deeply obliged.
Item 11.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
The record has been arrived. If the matter may be taken up for admission hearing on next week, Thursday.
Paper book is not required.
Yes, my lord.
Learned counsel for the appellant, Mr.
Somdong Zela Tilum.
Mal Somdong Zela Tilum.
Yes, my lord.
Tilum. Submits that the TCR has arrived and the matter may be listed for admission in the coming week. Mr.
Seatlan Thiang Lim.
Seatlan Thiang Lim, learned counsel appears for the
Sole
sole
respondent.
respondent and agrees to the prayer.
My lords, if it can be taken up on Tuesday, my lords, I have some difficulty on Thursday. This morning, the conducting counsel had called me that he may pray for on Tuesday to list the matter on
Who is
Tuesday.
the conducting counsel?
Mr. Lalbiag Nungan Hamte. So the date we agreed was for Tuesday.
Okay. It's agreed to by the parties. List the matter on Tuesday. Huh? The date is 28th July.
Oblige.
Item 12.
I would like to seek your lordship's indulgence in item 12 on behalf of my learned friend, Mr. H. Lal Monkema, my lord. There was bereavement in his family. His brother passed away day before yesterday.
This IA is for written objection to the special leave application, my lord.
It has not been filed.
Not been.
This is similar, like the other case.
Yes, my lord. Similar in the sense that is under PC Act as well, and is against acquittal, my lord.
Against acquittal.
Yes, my lord.
Okay. Mr. Silal Fagzor, learned counsel for the applicant, submits that by filing this application, the applicant seeks special leave to file appeal against the acquittal of the sole respondent. Mr. Lal Fakoma, learned counsel, submits that he has been requested by Mr. H. Lal Monkema to seek adjournment as he is in bereavement.
My lord, his brother passed away yesterday, day before yesterday.
In view of above, matter stands adjourned for
2 weeks.
2 weeks.
Oblige.
Respondent may file objection in the meantime.
Oblige.
Item 13.
May I please, Your Lordship? Lordship, I have placed one list of dates that Lordship kindly peruse, Lordship. There, Lordship, on 6/3/2025.
Just a minute. Just a minute. You are there for?
Appearing on behalf of Mr. Sizoram Sana, my senior,
Yes.
Special PP, NCB.
So,
I've received a notice that
we'll issue notice.
Lordship may fix for short date, Lordship, because there is a violation of section 47, 36 and 48, Lordship. And nothing was recovered from him, Lordship.
Lord,
I.U. Chaudhary, Lordship.
Mr. I.U. Chaudhary through RVC, who submits that by filing this application, the applicant seeks bail. He submits that the applicant was arrested and is in judicial custody since 10/4/2026. Learned counsel submits that there is gross violation of the mandatory provisions of section 47 and 48 of the BNSS, amongst others, and therefore the applicant may be released on bail. In view of above, issue notice returnable by, when do we list?
2 weeks.
Case diary will be
Lordship.
required. Case diary will be required.
Lordship may fix for short date, Lordship.
We listed on 30th, returnable by 30th of July 2026. Mr.
Lalven Sanga.
Lalven Sanga, learned counsel, accepts notice on behalf of Mr. C. Zoram Chana, learned senior counsel and special PP,
NCB.
NCB. Applicant to serve copy of the bail application to the learned special PP within 2 days, if not already done.
Already done, Lordship.
The learned special PP shall produce the case diary on the next date. List accordingly.
Lordship. Deeply obliged, Lordship.
From supplementary course list, item 14 for motion.
My Lord, seek your Lordship's indulgence in entertaining this review petition. This is against that order passed on Monday regarding
What was the
that leave for filing a third-party appeal. Your Lordship, just to revisit the facts of the case, Your Lordship, the applicant had allegedly purchased one property, a building situated within a property from one respondent number 2, although the property was registered in the name of the respondent number 3. The applicant had relied upon the sale deed that was executed between himself and the respondent number 2, and the registered owner was not a party. So based on that, he was claiming his rights, title and interest over that property. The leave that was granted is at page 19A, Annexure 1. This is order dated, judgment dated 27/2026. Relevant paragraph starts from page 23, para 9. May I read, Your Lordship?
Yes.
It is the case of the applicant that he has purchased an RCC building from the respondent number 2 on 12/12/2022, and the same is situated within LSC number so-and-so, which is registered in the name of the respondent number 3. The applicant, in order to support his contention, has filed an additional affidavit on so-and-so, including a copy of the sale deed. A perusal of the sale deed, annexed as Annexure 5 to the additional affidavit, goes to show that the purchased building covered by the LSC number so-and-so has also been said to be covered by the plot number 108. It therefore appears that while the sale deed was prepared and signed on 12/12/2022 by the parties concerned, including the respondent number 2 as the seller of the building, she had knowingly entered into a compromise agreement with the respondent number 1, who is the plaintiff in civil suit number 40 of 23. Therefore, the very fact of non-disclosure about the selling of the building standing in the LSC of 2005 under plot number 108, and also non-filing of any objection in the instant application, either by the respondent number 2 and 3, despite notice, prima facie goes to show that the applicant can very well be the party aggrieved in view of the manner in which civil suit number so-and-so was disposed of by way of a compromise agreement. As already noticed in paragraph number 5 of the compromise agreement, which projects the applicant to be merely a relative staying temporarily in the said building, while the applicant maintains that the building was purchased by him, though some balance amount remains to be paid. The apex court in the case of so-and-so, in the given facts of that case, held that a perusal of section 96 to 100 of CPC makes it clear that the provision are silent about the category of persons who can prefer an appeal. However, it is a well-settled legal position that a person who is affected by a judgment but is not a party to the suit can prefer an appeal with leave of the court in the present case as well. As already noted, that it prima facie appears that the applicant is affected by the disposal of the civil suit by way of a compromise agreement. Accordingly, upon due consideration, this court is inclined to grant leave to the applicant to prefer the third party appeal. In my humble opinion, Your Lordship, I believe that if this is not revisited, my Lord, a very unwanted and unintended legal precedent will be set, inasmuch as, my Lord, the same would amount to condoning and legitimizing a sale of a property by a third party without the knowledge and consent of the registered owner. That is number one, Your Lordship. Because the facts itself shows that the sale deed was executed between the applicant and the respondent number 2, who is not the registered owner. Registered owner is number 3, as I've just read out. So that would amount to condoning and legitimizing a sale by a third party of a property.
No, it cannot be in that way, Mr. Thakuma. See, the main thrust of this, purpose of this order is to bring in another person who says that I am affected. So it's basically a prima facie view of this court. It's not that the sale has been legitimized or court has, recognized that sale as you submitted.
Okay. Assuming.
So it's only basically for the purpose of considering the present application, whether he should be given the chance to contest the appeal or not.
But that interpretation is quite possible, Your Lordship. But the interpretation is quite possible that it amounts to condoning and legitimizing a sale of a property by a third party. Because tomorrow what will happen? If my neighbor sells my property without my knowledge, that will be legitimized by way of this order. That is one thing. Another thing is, Your Lordship, assuming but not admitting that the sale was properly conducted. The document which the applicant was relying upon, that Annexure 5 of the additional affidavit, which I've annexed at page 130, the last 2 pages.
130.
130. So Your Lordship may notice that, so signatures are there, property is mentioned. So, in my humble opinion, to invoke the protection of protecting his interest over a property and say that his rights under Article 300A has been infringed, I think the first thing the applicant has to show is that he has rights, title and interest over the property.
See, Mr. Fakoma, I'll repeat again, this is basically an appeal by a third party who says
Correct.
that I'm aggrieved. You say that you have no interest in this case. He says that I have some interest. So this leave was filed and court has given an observation that perhaps he has some grievance. This has to be tested in appeal.
Understood.
There is
my
no
lord.
finality of the order.
Understood. The apex court's judgment, which Your Lordship has also reproduced in the order itself, out there it was clearly mentioned that the injury suffered by a party in order to prefer a third party appeal cannot be imaginary, cannot be psychological. It has to be a legal injury. In order for him to suffer a legal injury, number one is that he must have a legal right over the property. So out here, by relying on this document, he is saying that I have suffered a legal injury because the property which I have legitimately purchased has been given away in a compromise agreement to which I was not a party, so I am aggrieved. That's what he basically is saying. But perusal of this 130 clearly shows that this is an unregistered document. It is not registered with the authority. Section 100 of the Mizoram Land Revenue Act, my lord, Section 100 of the Land Revenue Act clearly states that any transfer of property will have to be by way of an instrument duly registered as per the Indian Registration Act. This has not been registered, so there is no question of the title being transferred to this particular applicant. He has to show that he has suffered a legal injury, not any injury.
All right, I'll clarify that.
My
I
lord.
don't think review is maintainable. Mr. Fakoma.
At least, I believe that as an officer of the court, it was my duty to point out my, of
Okay,
course,
please.
decision is ultimately up to your lordship.
Please write, heard Mr. Lal Fakoma, learned counsel for the review petitioner. The instant review petition has been listed, has been taken up as an unlisted item today on a mention made by the learned counsel. Stop the learned counsel submits that by filing this review petition, the petitioner seeks review of the judgment dated 27/2026 passed by this court in IAC number 178 of 2024 on the ground that by the said judgment, the rights of the third party has been legitimized despite the fact that there was no legal instrument to show that the property in question had been purchased legally. Stop. The learned counsel submits that if review is not allowed, the same would
Unintended precedent, your lordship.
lead to unintended precedent. Stop. upon considering the, and precedent, and therefore the order, the judgment dated 27/2026 may be appropriately reviewed. Stop. Upon considering the submission made by the learned counsel for the petitioner, this court is of the view that the instant review petition at the outset is not maintainable on the ground that the observation made by this court, the view expressed by this court in allowing the leave to file third party appeal primarily is a prima facie view taken by this court, and under no circumstances the same can be considered to be a final decision. Stop. In other words, the said judgment has only given an opportunity to the third party to project his grievance through the appeal that he intends to file. Stop. In other words, the view of this court being only a prima facie view, the same cannot be construed as a finality in the decision over the issue in question. Stop. The parties, including the review petitioner, would be at liberty to contest the appeal wherein, based upon the materials available on record, the court would be required to take a decision in the matter. Stop. The legality or otherwise of the sale deed, which according to the review petitioner is not a legal document, would also have to be considered in the appeal, in the third party appeal.
No, in the main appeal, Your Lordship. It would be in the main appeal now since he's already allowed.
In the main appeal. Stop. Therefore, the instant review petition is found to be without merit and the same is dismissed. However, with the above observation. Yes.
So, my lord, so the issue of what I've raised out
It'll
here,
be
that can
open.
be that can be adjudicated by the appellate court.
That the appellate court will decide whether
On
it
these
should,
issues.
it should adjudicate or it should send it back to somebody.
On these
Yes,
issues
I
as
have-
well.
I have left it open.
All right.
The clarification is there.
That's all we wanted, Your Lordship.
All right.
Deeply obliged.
From admission list, item number 1.
My lord, this matter pertains to second schedule of the 2013 Right to Fair Compensation Act. Now today, the respondent number 8 is yet to file her affidavit in opposition, my lord.
Your Lordship, I'm representing.
Just a minute. What is this second schedule
Yes,
of what?
2013 Act, Right to Fair Compensation.
Okay, you're claiming compensation
We are claiming compensation as a tenant.
as a
Tenant,
tenant,
yes,
which is admissible,
yes, which is provided in the
which is
second
provided
schedule.
in the second schedule.
Yes, my lord.
You are a tenant of which land?
Of the landowners in Tlabung. The land of the landowners has been acquired.
Okay. And there's no affidavit yet? You want some time?
Your Lordship, I have given the copies of the affidavit today, and attempt will be made to file the same today before the registry.
You have received a copy?
Yes, my lord.
Okay. Mr. Silal Fagzola, learned counsel for the petitioners, submits that he has received a copy of the affidavit in opposition filed by the state respondents. What about union
Union, they are not filing.
and NBCC is there? NITDCL?
My lord, we've already filed our affidavit in opposition, my lord.
That means Lunlu is appearing for whom?
Your Lordship, Kala Lule.
Oh,
8.
okay. What did I say, Mr. Sil Fagzola? Filed by the Kala, CALA. Stop, Ms. Lalun Louis, learned government advocate representing Kala, however, submits that the affidavit has been supplied in advance and the same will be filed during the course of the day. Insofar as the remaining respondents, such as the NHRDCL and the state respondent numbers, Caroline,
5 to 7.
numbers
5 to 7.
5 to 7, comma, they have already filed their counter affidavit. But what about CGC? You'll be filing?
CGC chance has been closed, I believe, in the
Oh,
last
chance
one.
is closed.
Yes, my lord.
Okay. Who's respondent number 8? Kala? Okay. CGC, where, by which order it was closed?
Let me see.
In view of above, list the matter again after a week.
My lord, if we could have a fixed date, that is the 25th of August, my lord. Because the senior advocate, Mr. PJ Saike, will be leading the case, my lord.
Is it agreeable to everyone?
Yes, my lord. I agree that.
In view of above, as prayed for by Mr. Samuel Vanusheta Changte, learned counsel for standing counsel for the NHRDCL and as agreed to by the other parties, list the matter on
25th of August.
25/8/2026.
Deeply obliged, my lord.
Oblige.
Item number 2.
May it please your lordship, I have filed the rejoinder affidavit wherein I have enclosed the RTI reply by the deputy commissioner stating that the lands, the house passes claimed by the petitioners are within the ROW and they have not been compensated.
Who's appearing for 1, 5, and 6? Lian Ming Tanga. Who's that?
Hello, we are for respondent number 6. Even though my drafted affidavit had already been sent long time back, not yet returned for filing, my lord. I may be given some more time for filing my affidavit.
You are filing affidavit on behalf of only 6?
For respondent number
1, 5, and 6 sir.
Respond number?
5 and 6. 1, 5, and 6.
And you file rejoinder on behalf of whom? Oh, against the affidavit of state respondent.
The state respondents, my lord. And my lord, basically this case pertains to non-compensation of the lands of the petitioners, which falls within the ROW.
Anyway, let them file the affidavit. We will
Yes, my
see.
lord. It's
How much
been-
time should you require?
My lord, I already sent reminder also.
We'll give you 2 weeks' time
Yes, my
as
lord.
a last chance.
Yes.
You don't file, you don't file. Mr. Zoram Chana, learned counsel for the petitioners submits that he has filed rejoinder. He has already filed the rejoinder affidavit on behalf, rejoinder affidavit against the affidavit in opposition filed by the state respondents. Ms. Zaram Sangpui, learned CGC, appearing for respondent numbers 1, 5, and 6, submits that the affidavit in opposition of the said respondents has been sent for vetting, but she has not received back the same, and therefore prays for 2 weeks' time. Now, it is seen that several opportunities have been granted to respondent numbers 1, 5, and 6 to file their affidavit, and therefore one last opportunity is granted to file the same, failing which court may consider proceeding with the matter on the basis of materials available on the court. This is the matter again on after 2 weeks.
Obliged, my lord.
Item number 3.
Your Lordship, I'm appearing on behalf of the state respondents number 1 to 5, and I will be filing my affidavit in opposition by today or tomorrow.
Okay, Ms. Caroline K. Lumapui, learned government advocate, appearing for the state respondents, submits that she will be able to file the counter affidavit within 2 days. In view of above, list the matter again after a week.
Item 4.
One more line, Mr. Vandal Khaka, learned counsel, appears for the petitioner. Okay. Item 4. Yes.
Your Lordship, on behalf of the state respondents, I have received a pair-wise comments, and I may be given a week's time to file my affidavit in opposition.
You are appearing for
State respondents number 1 and 2.
1 and 2. Then what about the others? 3, 4, 5, 6? No. Okay. Like how much time? Parties are represented by the respective councils. Of the respondent number 5 and 6 have already filed their counter affidavit. Ms. Caroline K. Lumapui, learned government advocate, appearing for respondent numbers 1 and 2, submits that she has received the pair-wise comments and will be able to file the affidavit within
A week.
within 10 days.
Yes, Your Lordship.
Then Ms. Zaram Sangpui, learned CGC, appearing for the respondent Union of India, submits that she is yet to receive instructions in the matter and therefore prays for 3 weeks' time to file counter affidavit. In view of above, matter stands adjourned for 3 weeks to enable the parties concerned to file their counter affidavit. List again after 3 weeks.
Item number 5.
Your Lordship, I am appearing on behalf of the state respondents number 1 to 4 and 6. However, I have not yet received any pair-wise comments from the department. If I may be given another 3 weeks' time to file my affidavit.
Lordship, there is urgency in this matter. It's pending for about 1 year now, Lordship. And then there is a plenty of time. Opportunity has already been granted to the state respondents. And Your Lordship, more specifically, I would like to point out the order date 3/2/2026, this year, Lordship. At this time also, Your Lordship, we strongly oppose the time prayed by the opposite parties, respondent, Lordship. 3/2/2026. We strongly objected the time, Lordship. And due to this pendency of case, Lordship, there is a stay of compensation process.
What is the matter?
This, in fact, originates from land dispute between petitioner and respondent number 7, Lordship. However, Lordship, a complaint was filed before the settlement officer. The settlement officer decided the matter in my favor. And again, by way of appeal, director was approached. The director again decided in my favor. Thereafter, the secretary was approached. The manner in which the secretary was approached is now in question now, Lordship. So my case, my issue in this case is that the secretary has no authority to entertain the second appeal. As per the Land Revenue Act, more specifically Section 89, read Section 92, the secretary could not entertain this matter by way of second appeal. And even if it's to be read as revision, it could not entertain, Lordship. So the main issue involved in this matter is that even though it's originated from the land dispute, it is mainly concerning with as to whether the Secretary, Land Revenue and Settlement Department can entertain the second appeal in a land dispute matter.
Who has decided first? The
Settlement official, Lordship.
settlement officer. Then appeal was filed before the director.
Director, Lordship.
Then thereafter before the secretary.
Secretary, Lordship.
All right, we'll give them one last chance.
At least 1 week, Lordship. Because it's been a very long pending case.
Instructions will come from where?
Lordship, let me make an attempt from the concerned departments,
Hmm.
from the revenue department.
So how much time? Don't take 3 weeks time. Take a shorter time.
At least
1 week.
At least 2 weeks time, Your
Okay,
Lordship.
we'll grant you 2 weeks time. Miss Caroline Magui, learned government advocate appearing for the respondent numbers 1 to 6, submits that she is yet to receive instructions in the matter.
Your Lordship, 1 to 4 and 6. 5 is Kala.
I see. 1 to 4 and 6, excluding 5, huh? Submits that she is yet to receive instructions in the matter and prays for 3 weeks time to receive instructions and to file counter affidavit. What about Kala? Anyone appearing?
Yes,
Already filed.
Kala, they
affidavit.
have already filed, and respondent number 7 also.
Who is appearing for Kala?
Mr.
Jonathan
Jonathan.
Dalin Plong used to appear in this case.
Okay. It is seen that the respondent number 5 has already filed counter affidavit,
7 also, my lord.
and likewise the respondent number 5, who is represented by Mr.
Jonathan is still silent.
Jonathan is both Kala and this.
Jonathan Dalin Plong, that is respondent number 5. 7 is Jonathan Silo.
Oh,
2 Jonathan.
okay. And this is represented by Mr. Jonathan Silo.
7, yes.
Hmm. Stop. Mr. Tilan Luciama, learned counsel for the petitioner, on the other hand, submits that the case has been pending for the last 1 year, and the state respondents ought to have filed their counter affidavit long time back. Stop. He submits that the issue in the instant case is as to whether a second appeal would lie before the Secretary to the Government of Mizoram Revenue Department. After the dispute between the rival parties has been decided by the settlement officer and thereafter the Director of Land Revenue and Settlement Department, in the appeal filed by the respondent number 7. So, next para, considering the above, one last opportunity is granted to the state respondents to respond to the writ petition for the ends of justice.
Failing which, Lordship, the
Listen.
matter may be proceeded in the absence of their affidavit. Lordship.
List again, we'll have a date.
6, Lordship, 6 August.
Today is 20.
Yes, it's the second week, Lordship. Today is 24.
We'll have it on 10th of August.
Lordship.
List the matter again on 10th of August 2026. Copy, it is made clear that if the affidavit is not filed by the state respondents by the next date, the court may consider proceeding with the matter on the basis of materials available on record.
Much obliged, Your Lordship.
Item number 6.
My lord, in this item, I am representing.
Just a minute. Miss Caroline, even without your parawise comments, you can argue, you are to prepare whether secretary can again entertain such kind of appeal. It's on that point. So you need not go here and there. You just have to stick on the law point, whether it's possible or not, under the revenue laws. Yes.
My lord, I am appearing for respondent number 7. So, my lord, I am seeking a week's time to file my counter affidavit. The proposed deponent, Mr. Pratik Gowda, will be arriving today from Silchar, my lord.
My lord, a fixed date may be given. Because in this matter, my lord, the work has already been commenced in the year 2024.
What is the matter regarding?
This is a writ petition under Article 226 for issuance of appropriate writ because my land has been acquired with construction work for the National Highway 154, 42 km to 58 old trainers in Bairabi area has been constructed. Even after my land has been acquired, no compensation, which has been approved by the respondent number 1 and 2, yet not been paid to us. So the construction work has been ongoing for a very long time without receiving any compensation, which is to be given to us.
Construction of what road?
Yes.
Which road?
National Highway 154.
Which area?
Bairabi area.
The construction of road has affected your land.
Yes, my lord.
You have not been compensated.
Yes. A word has been passed. It has been finalized. The Kala has, the state respondent has submitted the what, but it's still pending for approval in the MORT. Respondent number 1 to 2.
So your name is also included?
Yes, my lord.
To receive the what?
Yes, my lord.
Compensation?
Yes, my lord.
So it is not that your name has been excluded.
No,
Correct?
my lord. Yes. But since the work has been already commenced way back in 2024 without disbursing any compensation.
So when are you filing affidavit? Today?
Within a week, my lord.
Within a week. Mr.
Larokung Apautu.
Larokung Apautu, Learned Counsel, appearing for respondent number 7, submits that he will be filing the affidavit of respondent number 7 within a week. Stop the Learned Counsel for the petitioner expresses urgency in the matter, since the construction work is in progress. In view of above, list the matter after a week.
Anyone for hearing matter?
The hearing matters, whatever is left now, you can say that.
Hearing was to fix the